Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to continue the story of Richard Sr. Richard Sr. was a police officer. He was found guilty of a number of corruption-related offenses as a result of an extensive police sting. Essentially, they thought he was misusing police databases, so they decided that they were going to investigate him. To do that, they had an undercover operator assigned as his partner. They also wired up his police vehicle. They bugged it. They bugged his personal vehicle. They bugged his cell phone. They also got him in touch with a confidential human source. They ran this whole operation to make him think that he'd recruited essentially a snitch. And they got him thinking that this guy was a major player in fentanyl trafficking and so forth, but that he was also giving them information on that was letting them make big seizures, big stings. So Mr. Senior was getting these various reports saying, thanks to your information, we were able to seize all of these drugs, all of this money, all of these weapons. Isn't that great for your career? But everything that was going on in Constable Senior's life at this point was basically being engineered to see if they could, snag him up in something criminal. So I went through the facts in a lot more detail in some previous videos, also some of the previous allegations. We're going to continue here with the law in relation to uttering a forged document. So the forged documents here, he's got a couple of sort of reports of a confidential human source, one of which he authored, and then he put somebody else's name down as the source of it because he didn't want to indicate that he was the guy providing the information on his ex. The other one is in relation to payments that went out to Henry Wong, that sort of fake major confidential human source, but Constable Senior ended up getting the money. He was actually acquitted of getting the money for that source. So continuing on here, in order to find Constable Senior guilty of uttering a forged document, this court must be satisfied of the following essential elements beyond a reasonable doubt. A, that the document was forged. B, that Constable Senior knew or believed that the document was forged. C, that Constable Senior dealt with the document, so he had to have handled it in some fashion. And D, that Constable Senior represented the document as genuine. So all of these are what lawyers call, the essential elements of the offense. These are, when you read a criminal statute, like a criminal law, you can break it up into the different bits that the Crown has to prove. And the court's done that here. So that's very helpful. A forged document is a false document made by a person who knows it is false and who intends that it be dealt with as if it were genuine to the prejudice of another person. So harming another person in some fashion or putting them at a disadvantage. It does not matter where or by whom the document was forged. So there's a lot to this definition here. The document has to be false, and it has to be made by a person who knows that it's false. So not an accident, not a mistake, and who intends that it be dealt with as genuine. So if you think of, if this is a movie prop or something, nobody's expecting this to be dealt with as genuine. It's just for a movie. So continuing on here. Section 366 of the Criminal Code provides that making a false document includes. So there's different ways you can make a false document that are specifically spelled out in the Criminal Code. However, the language of includes means that in theory, there are other ways that one could do it. It's just these are some specific things that definitely count. So altering a genuine document in any material part. So if we think about what this means, let's say somebody gives you a check and that check is for $50. And you take that document and you alter it by making it say $500, and then you cash it, and now you've got $500 instead of $50. That would be making a false document because you've altered it in a material part, to wit, the amount. Let's say you find a check. Somebody got paid and you find it on the road and you erase their name and you put your own name in place. That would again be altering it in a material part, which is who that check is payable to. Making a material addition to a genuine document or adding to it a false date, attestation, seal, or other thing that is material. So all sorts of ways that could happen. C, making a material alteration in a genuine document by erasure, obliteration, removal, or in any other way. So as an example, let's say you've got a deed that says that a particular item belongs to Joe and to Frank, and you're Joe. And so you go and you erase the and to Frank part. So now it just says that it belongs to you. That would again be making a false document. So there's lots of ways this can happen. The court references the case of the Queen and Gasek, in which the court held that a document which is false in reference to the very purpose for which the document was created is certainly one which is false in a material particular. So if you think about it, there's various things, like let's say you've got a big document and you note that on the day in question it was raining and nothing turns on that. That may not be a particular, a material particular. Essentially, they're saying it has to be something that matters. The difference between the offense of forgery and the offense of uttering is of use. So these are two separate charges in the criminal code. Forging is the making of a false document. Uttering is its use. So let's, if you manufacture a driver's license that is a fake ID, that would be forgery. But let's say you go and you buy a fake ID from somebody else, and then you go to the bar and you use that fake ID. That would be the offense of uttering a forged document. You are providing that as identification, and it's not true, and that gets you into trouble. So, analysis and conclusion in relation to uttering a forged document. I'm skipping over a fair bit here just to try to keep this concise. The law, it's good that judges go through a lot of detail in explaining their decisions. That is something we want from the judicial system, especially on a case that is kind of high profile, kind of a big deal. And I suspect that there's potential challenges down the road on this one. So it's good that the judge is putting a lot of effort into explaining themselves, but we can get the idea with less here. So continuing on. As for the Broadhead payment, it is the view of this court that there's more than ample evidence, as set out above and earlier in this judgment, to support the fact that Mr. Wills was being asked to forge David Broadhead's signature on the payment form. So, Mr. Wills is a friend of Constable Senior. Constable Senior asked him to fake the signature of David Broadhead. David Broadhead is somebody that Constable Senior thinks is a sort of sketchy guy, somebody who's involved in sort of low-level stuff. I don't know David Broadhead. I don't know any details. I don't know that he's ever been convicted. I don't know anything about him. But these are sort of this is what Constable Senior seemed to think. Constable Senior and UC1, that's Undercover Operator 1, Constable Senior's fake partner, had clearly prepared the intelligence report with information provided by Constable Senior and, to a lesser extent, with information recovered from police databases and social media. There was no suggestion that any of the information was coming from Mr. Broadhead, or for that matter, from Mr. Wills. There was no suggestion that Mr. Wills was authorized to sign anything on behalf of Mr. Broadhead. The intercepted communications or conversations between Constable Senior and Undercover 1 demonstrated that Constable Senior was searching for a source name to put on the intelligence report and that he chose a name. If you haven't watched previous videos and you're wondering why it's UC1, it's because this is an undercover cop. He operates doing various other undercover operations, and they don't want to put his name into a public-facing document like this. There's actually a publication ban that bans revealing his name, so even if I knew it, which I don't, I wouldn't be able to tell you. So with respect to the payment, Constable Senior and UC1 debated what to do with the cash, knowing that there was no confidential human source, but rather Constable Senior was the source of the information. Ultimately, Constable Senior stated that he would get someone to sign off, which was exactly what he did. The intercepted conversation between Mr. Wills and Constable Senior establishes, beyond any reasonable doubt, that Constable Senior asked Mr. Wills to forge Mr. Broadhead's signature. Constable Senior was most certainly aware that Mr. Wills was forging the signature. He explicitly asked him to do it. He used those words. He said, can you forge this signature for me? Constable Senior then dealt with the document by submitting the payment form to Detective Sergeant Bedford, which indicated that Mr. Broadhead had signed for and received the money. This was most certainly not true. Constable Senior represented this document as genuine, as having been signed by David Broadhead, and as indicating that David Broadhead had accepted the $300 payment. Clearly, this was an attempt by Constable Senior to deceive Detective Sergeant Bedford as to the source of the information and payment of that source. Now, if you've watched previous videos, you know exactly why this was going on, because UC1 encouraged him to make the report, knowing that Constable Senior didn't want his name on it, and then basically sort of left him to panic about what had happened there. So they kind of wedged him into a difficult situation here. Detective Sergeant Bedford, of course, would not have been deceived here. It seems that he was in on this whole ruse here, because he was sending out some of these fake, we seized a whole bunch of guns and money and so forth emails. So, yeah, he was never going to be successful with this. As for the documents submitted in relation to the payments to Henry, there is insufficient evidence to establish beyond reasonable doubt that Constable Senior knew any of the information in the CHS payment form signed by Henry on August 29th and September 10th, 2018 to be false, because Constable Senior believed Henry was a real confidential human source. On August 29th, Henry signed the form and accepted the money. Though he abandoned the money in Constable Senior's presence, the background on this, he takes the money and then he leaves it on a table and basically insists that Constable Senior take it, which eventually seems to happen. On September 10th, while Constable Senior did not explicitly alert Henry that the money was there and his for the taking, Henry signed the form and the money was made available to him. So in this case, it was sitting in a cup holder, it was in open view, and Henry had been indicating that he was insulted by this money, he didn't want it, that it was offensive to him that he was being offered this money because it's such a small amount and it's kind of an insult. Here, have a dime is kind of, the issue. So it seems like Constable Senior was saying, hey, listen, you have to take this money. This is what they want, in terms of how the bosses like to do things. But Henry was making it real clear he didn't want the money. So it is not the only reasonable inference that Constable Senior knew that the forms were factually false, or that the form itself was rendered false by virtue of Henry's abandoning the money. And this makes sense to me. Henry signs for the money. At that point, it's his money. And if he, so he took the money, or he accepted the money, and then he chooses not to keep the money. Fair enough. So I agree with this reasoning with respect to the Henry, and frankly, with respect to the David Broadhead. It makes sense. So Constable Senior is found guilty of count 3 as it relates to the payment form attributed to Mr. Broadhead only. So he's guilty, but not of everything they're alleging. So intelligence report regarding Sherry Wafer, which is count 2, uttering a forged document. So continuing on here, apart from the name of the source, there is no reason to believe that the information contained in the intelligence report was untrue. So he provides a bunch of information suggesting that his ex is involved in some sort of drug activities, and that's because his ex was actually, he was having an affair with her, and his wife found out about this, and for some reason he seems to be upset with her, and so wants to get back at her. Not really the kind of behavior or personality traits that I really want in a police officer, but that's not really what he's being charged for here. So apart from the name of the source, there's no reason to believe that the information contained in the intelligence report was untrue. While Constable Senior may have had personal motives for coming forward with this information, it does not make the information fictitious. However, that is not the focus of the charge. So he's not being charged with the fact that he had bad motives for making this report. The intercepts leave no doubt that Constable Senior had first-hand, direct personal knowledge of the information provided in this report from his relationship with Sherry Wafer, and that the information did not come from a confidential human source. Constable Senior did not even have the name of a source in mind at the time he authored the report, as evidenced by the communication between Constable Senior and Undercover 1. So all of this, again, was recorded on bugs. They've got all of that detailed. It was clear that, in the intelligence report, at least partially prepared by Constable Senior, there was explicit reference to a confidential human source. Constable Senior was clearly trying to distinguish himself from the source of the information. The intercepted communications clearly confirm that Constable Senior wished to hide the fact that he was the source of the information and was searching for a name with the assistance of Undercover 1 to place on the form as the source. Clearly, Constable Senior knew that he was, in fact, the source of this information, and that attributing it to David Broadhead was false. So basically, he doesn't want Sherry Wafer to figure out that he's the one who's reporting on her because, there's all sorts of reasons going on there. So he's putting down this David Broadhead name in order that she will never find this out. Which, again, sketchy. The intelligence report is false, both because it was made on behalf of a person who did not authorize it to be made, and because it is false in respect of material particulars. The evidence clearly demonstrates that David Broadhead did not authorize this report to be made, but rather his name was simply one chosen by Constable Senior when faced with a predicament. The report is false in respect of material particulars because it suggests that David Broadhead, the purported confidential human source, made observations that he did not make. The completed Form 257 confidential information report submitted by Constable Senior at the request of Detective Sergeant Bedford was also false and was meant to support the information contained in the intelligence report. That report set out the informant's name as David Broadhead, provided an address and phone number for the informant, as well as a location of the meeting with the informant. None of this was true. Constable Senior was clearly the source of this information. So we can see where the court is going on this one, right? When Constable Senior submitted the intelligence report about Sherry Wafer, along with the confidential information report to Detective Sergeant Bedford, he knew that it purported to relay information provided by a confidential human source. In fact, that was clearly his intention. This was false and misleading. Constable Senior was very aware that there was no confidential human source, and that the report was based on his own first-hand knowledge. Even the photos contained in the report came directly from him. The purpose for which Constable Senior submitted this intelligence report was to provide the police with information about Sherry Wafer that did not link back to him as the source. Even though Constable Senior may have been motivated by spite towards Sherry Wafer for alerting his wife to their affair, this court does not question that he believed the information that he provided and wished to trigger the investigation of a crime that he believed to be true. However, he fabricated the source of the information in order to remove himself from it. Constable Senior's false designation of David Broadhead on the related form that ultimately accompanied the report confirmed that Constable Senior's intention was to mislead Detective Sergeant Bedford about the source of the information he reported. The form identified RS as the submitting officer, RS as the confidential human source handler, and David Broadhead as the informant. Constable Senior is guilty of count 2, uttering a forged document in relation to the Sherry Wafer intelligence report. Now, when we go through the backstory, if you've been following along and, if you're just picking up, I'll try to explain a little bit here. He was trying to accomplish something and he didn't know how to do it. And his partner was giving him advice at different stages that kind of changes as it goes along. And it changes in a way that's designed to get him into this trap. And then once he's sort of in this trap, he's asking his partner, he's sending repeated messages basically going, what do I do about this? And he's not getting any help. So if he'd been sitting next to a partner who wasn't trying to get him into trouble, I really raise the question as to whether or not this would have happened. Clearly, this shouldn't have happened, but the amount of sort of effort and engineering they were going into to make it happen, to my mind, is concerning. So unauthorized use of computer database and breach of trust. This is what they originally wanted to get him on. This is actually the original thing that they thought he was doing. So it's good that that's at least in here, I guess. So law in relation to unauthorized use of computer database. So this has its own sets of laws and the court's going to explain them. So that's good. In order to find Constable Senior guilty of unauthorized use of a computer database, the Crown must prove the following essential elements beyond a reasonable doubt. First, that Constable Senior obtained a computer service. Obviously, right? You can't have unauthorized use of a computer database if you didn't use a computer. That the use of the computer service was prohibited, so not something that you're entitled to do. See, that a reasonable person in Constable Senior's circumstances would conclude that his use of the computer service was dishonest. D, that he acted without color of right, and color of right is a complicated legal concept. You don't necessarily need to be correct for color of right, but you can have circumstances where essentially you are mistaken, but you are thinking that you are doing the right thing or that you're justified in some fashion. And E, that Constable Senior intended to commit the prohibited act with the knowledge that he was wrong with respect to his use of the computer service. Fraudulently requires behavior that a reasonable person in the circumstances of the accused would consider a dishonest behavior. And I'm going to skip over a bunch here. The court notes in a case called Parent, the court held that a computer is used fraudulently within the meaning of section 342 sub 1 sub 1 or point 1 sub 1 when it is used intentionally, without mistake, with subjective knowledge that the use is unauthorized. Which sounds a lot like a rephrasing of what we just heard, but this is kind of how courts be very careful, is to get these different phrasings of how things are going. The facts of Parent are similar to this case. Mr. Parent, a member of the RCMP, was charged with fraudulently obtaining a computer service pursuant to the same section of the criminal code. He accessed information from CPIC, which he passed on to a private investigator. At trial, Mr. Parent admitted that the acts, but he contended he had not acted fraudulently. The trial judge agreed and acquitted Mr. Parent. However, on appeal, convictions were substituted. So at trial, he was acquitted, and the appeal court said, nah, that was wrong, and imposed a conviction. That's rare. They only really do that in situations where the facts are solid. Nobody has any dispute over the facts, but the lower court got the law wrong in a way that would have acquitted. So again, it's an unusual thing. Usually, when they're reversing an acquittal, usually they send it back for a new trial, but not always. In the case at bar, the accused admitted to the acts while knowing it was strictly forbidden for members of the RCMP to access the computer service for the benefit of a third party. A reasonable person would conclude that the actions were wrong. And this is quoting from Parent, by the by. So this is from the case within a case, if that makes sense. Moreover, the accused admitted that he had no color of right. The accused argued that his acts were committed openly and publicly without any attempt at concealment. However, this did not negative the dishonest nature of the acts. Moreover, the accused's motive of improving the efficacy of his investigations did not change the fact that he committed the prohibited acts. In criminal law, motive must not be used interchangeably with intent. This is important, right? Because we talk about intent in the law, but in the media, they often talk about, the motive. Motive can be nice to explain something, but it's not necessary. So the court says, indeed, a laudable motive does not neutralize criminal intent. In the case at bar, the accused acted deliberately and voluntarily, knowing that his act was prohibited. So to draw the distinction between motive and intent, think of a murder. Somebody might be killed because, hey, you owe me money, and, you owe me this drug debt. I'm tired of waiting. I'm going to just, make sure that you're an example to everyone else. And so, but that isn't intent. That's motive. That's the reason for it to happen. And ultimately, the Crown doesn't have to prove a motive. They don't need to necessarily understand why you did it. But in terms of proving the intent, and murder requires a very high level of intent, specific intent to kill. If they can show that, you had the guy kneeling down and you put a gun up to the back of their head and you pulled the trigger, that probably shows that you specifically intended to kill them, because what else is the explanation there? And let's say, this is somehow captured on video. After the person goes down, you fire several more shots into their, prone body, kind of suggesting a specific intention to kill there, right? So that's kind of an example showing the distinction between the motive and the intent. But they're saying here, a good motive for these offenses doesn't fix things. So long as your intention is dishonest in some fashion, that's good enough. So the court agrees with that reasoning, and they say that the accused acted without color of right is an element of the actus reus. Color of right refers to a situation where an accused can point to an evidentiary basis that he or she had an honest belief in a state of facts which, if they actually existed, would justify or excuse at law the act done. So let's say you take somebody's car, but you do so because you're a repo man and somebody else has provided you with a very detailed file showing that they have an active car loan on that vehicle, that they're entitled to repossess it, that they have court orders allowing all of this, and your job is just go pick up the car. You've been shown all of these things. Now, it turns out that the guy who provided you all those documents is a thief. He just wanted you to go steal somebody's car. And that person's car is paid in full. There is no repossession under it. You would have a defense under color of right. I didn't know that I was, I knew I was taking this guy's car, and I knew I'm not the owner of it, but I thought that I was entitled to do so based on these documents. That might be an example of a color of right sort of situation. So, law in relation to breach of trust. As for breach of trust, in order to find Constable Senior guilty of this offense, the Crown must prove each of these essential elements beyond a reasonable doubt. A. Constable Senior was an official. B. Constable Senior was acting in connection with the duties of his office. C. Constable Senior breached the standard of responsibility and conduct demanded of him by the nature of the office. D. The conduct of Constable Senior represented a serious and marked departure from the standards expected of an individual in his position of public trust. So marked departure is, you don't just have to be over the line, you have to be substantially over the line in some fashion. This is to avoid criminalizing just, small errors. And the court's going to talk about that a little bit further, so I'm going to leave it there and we'll see what the court has to say. Constable Senior acted with the intention to use his public office for a purpose other than the public good, for example, for a dishonest, partial, corrupt, or oppressive purpose. All right, so we've got all our elements of the offense here. Let's see the court. They're going to discuss them a little further here. They're discussing a case called the Queen and Boulanger. As the early cases make clear, the actus reus of the offense of breach of trust defies precise definition because of the range of conduct that it is designed to cover. So there's all sorts of ways you can breach trust. And so that's why it's written broadly. In Peralt, the court held that subject to the benefit requirement, subject 122 of the Criminal Code could be triggered by any act or omission contrary to a duty imposed by a law or regulation, by the accused contract of employment, or by a guideline connected with the accused duties. This echoes the earlier decision in Campbell to the effect that the offense was wide enough to cover any breach of the appropriate standard of responsibility and conduct demanded of the Crown by the nature of his office as a senior civil servant of the Crown. Wow, that's really broad, right? The court's going to narrow this, because if you think about how broad just that phrasing would be, you're into some serious, it'd be very difficult to be a police officer. So any attempt to limit the offense to specific acts or omissions would undoubtedly fail to foresee that all the circumstances in which an official might breach the public's trust. That being said, it cannot be that every breach of the appropriate standard of conduct, no matter how minor, will engender a breach of the public's trust. So, think about this, right? Police are expected to follow all of the laws unless there's some reason that justifies them breaking one, including traffic laws. So a police car that is not responding to any sort of, alarm or anything else, but is speeding, is breaching, the police standards. But I kind of think that shouldn't be instantly a criminal offense just because a police officer is doing it. As much as I say we should hold police to higher standards, that might be too high, right? It'd be very hard to be a police officer if getting anything wrong on a form meant that you had suddenly committed a criminal offense. There's got to be some room for screw-ups. I don't know anybody who's done any job where you haven't made some sort of mistake. Hopefully your mistakes are ones that you can recover from, that don't cause too much damage, but everybody makes mistakes. So, for example, the personal use of an office computer might be contrary to an employment guideline, yet not rise to the level of a breach of trust by a public officer. Officer on his work computer decides to check Facebook. Should they go to jail? I'm kind of thinking no, and the court is saying obviously not. Such a low threshold would denude the concept of breach of trust of its meaning. It would also overlook the range of regulations, guidelines, and codes of ethics to which officials are subject, many of which provide for serious disciplinary sanctions. In theory, there's all sorts of codes and conduct and so forth, but the public doesn't have a whole lot of faith in the disciplinary sanctions that we see coming out of police disciplinary procedures. But in theory, the tools are there. They're just not being used. But the court is saying, listen, if an officer is checking Facebook on a work computer, that's really something for the police to deal with. That's not a matter for the criminal courts. And that I agree with. So what is required is conduct so far below acceptable standards as to amount to an abuse of the public's trust in the office holder. As stated in The Queen and Crichton, the law does not lightly brand a person as a criminal. Now, I agree that that's a good principle, but the law does lightly brand people as criminals all the time. Somebody who goes and starts a fire in a trash can might be charged with arson. Somebody who takes a sandwich because they are desperately hungry can be charged with theft under 5,000. Even in some circumstances where, the person who later had this stolen says, I'd really rather they not be charged. Yes, they took the sandwich. Yes, they didn't have permission, but I'd really rather that they just eat the sandwich. They still get charged. You can be charged and convicted of an assault for something like, flicking somebody with your finger. So when we say the law does not lightly brand a person as a criminal, it kind of does. But I guess it is a fair statement to say that the law does not lightly brand a public official as a criminal. And there's a whole debate to be had as to whether or not that distinction is one that is fair or proper, but that is just where the law sits. So the test to be met in the inquiry is analogous to the test for criminal negligence. As in cases of breach of trust by a public officer, it became necessary in criminal negligence cases to distinguish conduct sufficient to attract criminal sanction from less serious forms of conduct meriting civil or administrative sanction. This sort of issue comes up in all sorts of scenarios. Let's take driving. There is a standard of perfect driving that nobody ever attains. You just can't. I don't think it's possible, because either you're going the speed of traffic on the road or you're going the speed limit, and most of the times you can't do both. But if we have this sort of notion of a perfect driver, most people fall short of that. And then there's sort of a range of falling short of that where you might get, a ticket. And there's a worse range of that where you might get, for instance, charged with careless driving under provincial statutes. But at some point, you're driving, if we go further down the sort of continuum of skill or ability or competence, at some point, it might become dangerous driving. There's a range where, let's say you're going really fast. You're going 100 kilometers per hour over the speed limit through a school zone at 3:05 p.m. So kids are just getting out. Dangerous driving. That's the point where we're talking about it becoming a criminal thing. So lots of situations require this consideration of this range of behaviors, from perfect to this is not so great, but maybe not criminal, to okay, now we're going to charge you with a crime. So to make this distinction, the Ontario Court of Appeal held in The Queen and Rajic that the conduct must represent a marked departure from prudent conduct. So not just a little mistake, but a big gap from what the appropriate behavior is. The Supreme Court talked about this in driving cases, which is kind of what I was referring to in the case of the Queen and Hundle. The public official's conduct must represent a marked departure from the standards expected of an individual in the accused position of public trust. However, unlike criminal negligence, the offense of breach of trust by a public officer also has a subjective mental element, to which I now turn. Consistent with fundamental criminal law principles, the bar for mental culpability for the offense of public malfeasance was an elevated one, so it's a high test. Mistakes did not suffice, nor did errors of judgment. So just because you made a bad decision doesn't mean you're necessarily a criminal. It's got to go beyond that kind of, it's got to go beyond oops into you did something seriously wrong. So the question has always been not whether the act done might, upon full and mature investigation, be found strictly right, but from what motive it had proceeded, whether from a dishonest, oppressive, or corrupt motive, under which description fear and favor may generally be included, or from mistake and error. In the former case alone, they have become objects of punishment. So more dense legal language. I don't know why courts write like this, although this is from a case of Boren. I don't know when that case came out. But basically it says, the test isn't did you do the right thing, but also what motive came from it. And they note that fear and favor, so if you're afraid of a bad outcome or you're looking for a good outcome, both of those can be included in that sort of corrupt motive notion and are distinguishable from a mistake or an error. So as with any offense, the mens rea is inferred from the circumstances. An attempt by the accused to conceal his or her actions may often provide evidence of an improper intent, right? So think about this one. Like, let's say you get a check and you think this is a valid, genuine check, and you just go and you cash it in your bank in the ordinary bank account. And it turns out that this check was, fraudulent. Somebody had given you a bad check, and, you can say, hey, listen, I clearly didn't know it was a bad check because I just walked into the bank. I put it into my own account. Like, I wasn't doing anything improper. But let's say instead you go through several steps to try to hide where this, so you create a fake bank account in somebody else's name. You're using a fake ID. You put the check in there and you immediately want to cash it out. And they say, well, those things where you're trying to create this fake trail show that you knew that the check was bad. So similarly, the receipt of a significant personal benefit may provide evidence that the accused acted in his or her own interest rather than that of the public. However, the fact that a public officer obtains a benefit is not conclusive of a culpable mens rea, so guilty mind. Many legitimate exercises of public authority or power by a public servant confer incidental advantages on the actor. Conversely, the offense may be made out where no personal benefit is involved. When we think about the incidental advantages, there's a lot of incidental advantages going on in this case. When Constable Senior is finding out this information from his source, Henry Wong, who again, undercover cop, feeding him false information. But let's imagine that Henry Wong was a real source and was providing him with this information, and because he's been able to result in a seizure of drugs, money, weapons, all sorts of stuff, that'll help his career, right? A police officer who does a good job and stops criminals is going to see a career benefit. So we can't just use the test of, did you get a benefit? Otherwise, we would capture a whole lot of stuff that we kind of want police to be doing. I want police to be doing a good job. I want them to be catching criminals. And I'm okay with the fact that a police officer who stops a lot of bad guys might get a benefit from it. Suffice it to say that not every breach of the appropriate standard of conduct will constitute the criminal offense of breach of trust. In the case at bar, the command directives themselves contemplate that some breaches can be dealt with by professional discipline rather than criminal prosecution. So again, they have the notion that they can punish internally. Not everything has to be sent to criminal prosecution. Now, I kind of feel like the police generally tend to not send enough stuff for criminal prosecution. When they have somebody and they say, oh, well, you beat up this motorist because they insulted you and you shouldn't have done that. That, to me, seems like something to be charged as an assault rather than something to proceed with through internal disciplinary measures. But that doesn't always happen. Skipping ahead a little bit further, they're going to go through this in some detail. I'm going to try to keep it to the key bits here. This is going to be a long video, but such is life. I do tend to occasionally do some deep dives into the law. In the Queen and Darnley, an OPP officer had been charged with breach of trust. The allegations were that the officer had accessed electronic police records and witness statements that police had collected during an investigation of a domestic incident involving her friend. There was also an allegation that the accused was filmed accessing and photographing a fake drug investigation file, which she shared with her fiancé, who was suspected to be involved in illicit drug use. This sounds like another police sting, right? How do you get this fake drug investigation file left for her attention if they don't suspect this? So maybe I should have a look at Darnley at some point, because it seems like there's some cloak and dagger going on in that one. In this case, the Court of Appeal for Ontario distinguished motive from purpose. Proof of a purpose other than the public good is required, while proof of motive, why a person acted in the way he or she did, is not. Also in Darnley, Justice Pacoccio rejected the argument that a police officer who was the subject of suspicion by superiors could not commit the offense of breach of trust because he or she was not actually in a position of trust. So let's break this down, right? So this is making clear that Darnley involves a sting, a trap laid for the officer. And so the officer's argument was, listen, I can't breach their trust because the whole fact that they're setting out this trap for me says that they don't trust me. So how can I breach this trust if they don't trust me? It's a clever argument, but it's not one that I think the court's likely to accept, because imagine what that means. It means essentially the instant you suspect somebody of being untrustworthy, they become immunized from this offense. That's not an outcome the court is ever going to want to go with. So proof of actual trust to the accused is not an element of the offense of breach of trust. As the elements of the offense make clear, the trust that is breached arises from the office held and the duties and responsibilities bestowed, not from a subjective belief that the accused is likely to honor the trust that the official's office requires. So because you are a police officer, or, this applies to other things, a politician, various other people could be in these sorts of positions where they can be subject to this charge. You have trust based on purely the fact that you are that official role. It doesn't actually matter if your superiors think that you're stealing, or if your superiors think that you are, some distrustworthy criminal. So all of this is, I think, the right call. It's the right interpretation of the law, and fairly critical in order for them to ever be able to prosecute this. So skipping over some other cases here, we're going to go through now in terms of analysis on the facts. So Constable Senior is alleged to have arranged through a work colleague, Constable Timur Timurbalatov, to run a license plate for George Paputsos, his friend and steroid contact, and then disclose this information to Mr. Paputsos. So not exactly a great thing here. All of the police directives entered into evidence at this trial make clear that access to police resources like CPIC is restricted to official police duties, and that the disclosure of information obtained from such resources is highly restricted. Relevant parts of the command directives provide that A, information from CPIC is classified as confidential for police only. It is a Police Services Act offense to divulge or show any CPIC information to an unauthorized person or organization. They say the same thing essentially about Paris information. Use of CPIC for anything other than official police business will not be tolerated. It is an offense to access it for purposes other than related to policing. Officers are responsible for the confidentiality and dissemination of information on CPIC and must protect it from unauthorized disclosure. And they can't record it on personal electronic devices. I'm going to skip over here. We don't need to go through all of those. On September 6, 2018, George Paputsos messaged Constable Senior to ask if he could query his license plate to make sure there were no complaints against him. Constable Senior said, "I might be able to run it tonight. Send it to me." Mr. Paputsos then texted the plate, BXLC238, to which Constable Senior stated, "Cool, I will have a car swing by the house." Hopefully Mr. Paputsos doesn't have that plate anymore, but I don't know. Mr. Paputsos stated, "Thank you, just let me know ASAP so I can put in a claim in the morning." Around 9 p.m., Constable Timur Berlatov texted that he was at Constable Senior's home, and Constable Senior replied that he was coming out. At around 9:03 p.m., Constable Timur Berlatov queried the license plate BXL-C238 on his mobile data terminal. Less than 2 minutes later, Constable Senior messaged Mr. Paputsos that he was clean and could make a report. The only reasonable inferences to draw from these facts is that Constable Senior had Constable Timur Berlatov run the license plate for George Paputsos on his mobile terminal, or that Constable Senior, logged in as Constable Timur Berlatov, ran the plate. So either is possible. Either, Timur Berlatov ran it himself, or George Senior just sort of leaned over and used his computer, which was logged in. Based on the information obtained, Constable Senior then disclosed to Mr. Paputsos that he was clean and able to make a report. Constable Senior's request that Constable Timur Berlatov run the license plate number provided to him by Mr. Paputsos, or Constable Senior running the plate as Constable Timur Berlatov, certainly raises questions of best practices for a police officer. However, the question for this court is not one of morality or best practices, but rather whether this behavior rises to the level of criminal conduct. There's no question that Constable Senior obtained a computer service and that the use of the computer service was prohibited in accordance with police directives. In this case, it would appear that instead of accessing it directly himself, Constable Senior used Constable Timur Berlatov to achieve indirectly what he could not achieve directly. So this initially starts to sound like evidence that he's hiding his behavior, right? And so that, if the court finds that, is probably going to be enough to land them on a conviction. However, let's continue on here. It is not clear to this court, however, that a reasonable person in Constable Senior's circumstances would conclude that his use of the computer service in this instance was dishonest. So that right there tells us what the outcome is on this set of charges, right? Constable Senior knew that George Papoutsos wanted this information in order to file a claim. It was information for George Papoutsos about George Papoutsos. This court is not convinced beyond a reasonable doubt that a reasonable person in Constable Senior's circumstances would conclude that this use of the computer database was dishonest. There's an allegation that Constable Timur Berlatov was at Constable Senior's home to drop off money to purchase steroids, which will be dealt with below. So, there's another explanation. It's not a great other explanation, but there's another explanation. It would appear, however, therefore, that the real purpose of Constable Timur Berlatov being at Constable Senior's home that night was not to run this plate, but rather to drop off money. Constable Senior appeared to take advantage of the opportunity of having a police mobile terminal at his home to have the license plate run. This court cannot conclude on these facts that Constable Senior knew that this action was wrong and was trying to cover it up by having Constable Timur Berlatov run the plate. That's a tough name. So given the innocuous reason for which this information was sought, this court cannot conclude that Constable Senior intended to commit the prohibited act with knowledge that he was wrong with respect to his use of computer service. Therefore, in relation to unauthorized use of computers as it relates to George Papoutsos, Constable Senior is not guilty. As for a breach of trust in disclosing the information to George Papoutsos, the defense suggested that Constable Senior did not actually disclose any information to Mr. Papoutsos, but rather confirmed the absence of information. Now, I've got tremendous respect for the defense counsel here, and you know what? I would have made the same argument. There's actually some case law to suggest that this argument is valid. I was on the losing side of that case. Maybe I'll cover that one. I probably shouldn't because it's my case, but I was on the losing side of a case on exactly this point, going in the direction that defense counsel was arguing here. So that's, the court found basically that a computer search that comes up with nothing is not information. It's the absence of information. So this court says this court disagrees with this characterization. There's no question that Constable Senior told Mr. Papoutsos that he was clean and could go ahead and make a claim. There's also no question that this amounts to disclosure. Disclosure is nothing more than making information known. Mr. Papoutsos did not seem to know whether his license plate was clean, and Constable Senior told him that it was. Certainly, this is disclosure. So this annoys me because I lost a case on this one and I'm still salty about it. And I would love to take this issue up and get it decided one way or the other by the highest court, which I think is, I think it's a question that's worthy of it, but it never made it there for various reasons. So this has me salty, but I do think that this notion of, hey, this is the absence of information might be a little, clearly he's providing some information to Mr. Papoutsos here, right? So the fact that a scan comes back with nothing is clearly information. If I run a check to see, does Joe have a firearms license, and I put Joe Schmo into the computer terminal to look up in the database of people with firearms licenses, and it goes, entry not found, I've learned something, right? This is new information. It tells me this guy doesn't have a gun license. So I get why defense is making this argument. I don't like it in these particular circumstances, but this is a sore point. This is kind of gouging me in an old wound. So this court has considered Constable Senior's knowledge of George Papoutsos. Constable Senior obviously knew that George Papoutsos had access to and was open to selling illegal substances such as steroids. It would also appear that Constable Senior knew, or at least believed, that George Papoutsos purchased cocaine given the conversation Constable Senior had with Henry on September 10th, 2018, that his friend George might be interested in purchasing Henry's product. Constable Senior also consulted with George Papoutsos about keeping 6 at the warehouse in exchange for cocaine. So George Papoutsos, maybe not such a great guy, at least in Constable Senior's view. I don't know anything about George Papoutsos. The court is not making any findings of guilt as against Mr. Papoutsos. This is just what Constable Senior believes at this point is what matters. The Crown submitted that it must be a marked departure for a police officer to provide confidential information from a police database to someone the officer knows to be a drug trafficker, irrespective of the circumstances. Now, I don't like this argument either, right? Irrespective of the circumstances, I mean, there's all sorts of circumstances that are going to be far less critical. If you think about it, if you say something like, hey, I was in a car accident, it's my old car, my insurer is asking me what my plate was, I don't remember what my plate was, but can you look up in your databases, what that car accident was? Can you tell me the plate from your databases? That might still count as confidential information. It's really low-end confidential information. I don't think that, if that would be something that is not a crime to provide to Joe Public, who doesn't have a record, isn't involved in anything, does it suddenly become a crime just because somebody, this person to be trafficking drugs? I don't think so. And the court says this court disagrees, so good. The request to have the information on his own license plate does not appear to have anything to do with his connection to the use or sale of drugs. Constable Senior's knowledge that Mr. Papoutsos was involved in dealing steroids and potentially using or dealing in other drugs does not undermine his understanding of what Mr. Papoutsos intended to do with the information, nor does it attach a dishonest, partial, corrupt, or oppressive purpose to providing this information. Now, those of you who have watched the previous videos are going, wait a minute. Yeah, foreshadowing. Constable Senior was certainly an official acting in connection with the duties of his office. Constable Senior breached the standard of responsibility and conduct demanded of him in accessing and disclosing this information to George Papoutsos, knowing that it was prohibited by the directives. However, in this context, the court is unable to conclude that the conduct of Constable Senior represented a serious and marked departure from the standards expected of an individual in his position of public trust. This court is unable to conclude that Constable Senior clearly acted with the intention to use his public office for a purpose other than the public good. The evidence does not establish that Constable Senior released this information to Mr. Papoutsos with a dishonest, partial, corrupt, or oppressive purpose. So Constable Senior is found not guilty with respect to breach of trust in relation to disclosing this information to George Papoutsos. Keep in mind, the standard for conviction is very high. Proof beyond a reasonable doubt. The courts sort of shy away from assigning percentages, but it's somewhere in the range of like 90 to 95% rather than like 50%. So the court can really think, we really disapprove of what Constable Senior is doing without being able to necessarily get to a conviction. Now, we're going to get to another use of unauthorized use of computers allegation, and this is with respect to Henry Wong, because Henry Wong asked Constable Senior to run a license plate for him for less laudable reasons. Let's continue. Now, keep in mind, Henry Wong is a cop. He's trying to get Constable Senior in trouble here. So Constable Senior is alleged to have run a license plate for Henry Wong and then took a picture of the results of the query with Henry Wong's phone and provided it to him. Constable Senior was well aware of who Henry was, or purported to be, and what he intended to do with this information. The following facts are relevant. A. On August 20th, 2018, Henry mentioned that he was having trouble getting an address associated with a license plate that would lead him to a storage locker that he was interested in. On August 25th, 2018, during a meeting at Cafe Atlantis, Henry stated, "That thing I am working on for you there, that's my priority right now, so like I said, if I can get that effer's address, that's going to be really good for both of us." Cafe Atlantis seems, I haven't covered that many cases about Toronto, or about this area rather, but Cafe Atlantis keeps coming up in cases. I'm thinking maybe if I'm visiting the area, It's just weird. I'm noticing that a couple of times here. So on August 30th, 2018, Henry expressed frustration because he could not get an address in relation to a locker for a personal rival, and that he'd been working on it for almost a month. Henry stated that he wanted the address so that he could rip his stash. So that doesn't sound good, right? Henry asked Constable Senior to query the license plate for him and give him the information so he could identify this locker to rip. Henry held out that his target was the runner for his rival and that the plate belonged to his target's daughter. Constable Senior said he could do it, but that it could get him into trouble. He suggested Henry go to the MTO or put a GPS tracking device on the vehicle. Constable Senior later asked for the plate and said he would see what he could do. On September 6, 2018, Henry asked about the license plate queries by stating, "And my rival?" To which Constable Senior responded, "On the hit list." On September 10th, 2018, in Constable Senior's F-150 in the parking lot of Milestones, Henry expressed frustration because he could not get the address of his rival. Constable Senior stated, "I told you what to do, brother," and suggested a GPS device being placed on the vehicle. Henry stated that he did not want to go that route. Right, because that doesn't get Constable Senior in trouble. Although, Constable Senior really should not be advising Henry about how to go about raiding his business or his business rivals. That is in and of itself a little sketchy, but maybe not as sketchy as pulling it up in the police databases. Constable Senior said, "If we take it, then we're taking it, you know what I mean?" Constable Senior suggested a number of times that Henry needed to be patient. Henry stated that he had a plate, but Constable Senior stated, "It won't come back to where you want it to come back to." Constable Senior suggested, "If I run it, then it becomes our thing, and then you can't touch it." Henry then stated, "Well, if you don't run it, you can get someone else to run it." Constable Senior stated that he could not, because then it comes up on the sheet, and then they go after it, right? So Constable Senior said, "All right, let me see what I can do. Get somebody off to do this off radar." Constable Senior said it would not be him or his partner running it. Constable Senior said that he could not promise anything, but would try and get it facilitated sooner than later. Constable Senior stated, "I got a couple of resources. They can backdoor channel it for me." So Constable Senior explained that he had to have a reason for running people. Henry explained that when he had the address, they would follow the individual to the locker and crack it open. On September 12th, 2018, Constable Senior tried to get Undercover 1 to run a plate for him. However, he refused. Later that day, around 9:45 p.m., Constable Senior queried the plate number supplied by Henry. So he does ultimately just run it himself, notwithstanding the fact that he said, "Hey, I can get into all this trouble and I got to get some, super secret squirrel method of doing it." He runs it himself. So Constable Senior approached Henry, talking a bit about problems in his personal life, and then said, "Give me your phone." And Constable Senior went into his truck. He then returned with the phone and told Henry to take a look, and told him to unlock his phone to look at his pictures. The photos that Constable Senior took were marked as Exhibit 13, because of course he's used a undercover operator's covert phone to take the pictures. He's thinking he's being super clever here, but he's actually making sure that the undercover has actually got the evidence. It was a screenshot of what appeared to be a CPIC terminal. Henry recognized the plate number, and there was an associated address. Constable Senior told Henry to keep it quiet. He remarked, "Now both our necks are on the line." "Oh, no, you're wrong about that. Just your neck, not Henry's. Henry's covered. He's good." So there's no question that Constable Senior accessed a computer database to run the license plate number for Henry. The police directives are clear that such activity is prohibited as set out above. The defense submitted that the intercepted communications between Constable Senior and Henry, as it related to the license plate query, were less than clear. For example, on September 10th, 2018, Henry rapidly switched back and forth between talking about providing information on future lockers and units containing illicit drugs and guns for the police to seize, and his desire to personally rip a rival's locker. His court strongly disagrees with the suggestion that the communications were less than clear. Strongly disagrees. So, I've said before, courts tend to use mild language. This is they're saying, no, we're not buying that one. Constable Senior knew that Henry wanted this information to rip drugs from a rival drug dealer. Henry said this explicitly to Constable Senior several times. The only assurance Constable Senior received that no violence would be used in this rip, or even that a rip was the real reason behind the request for this address, as opposed to something more nefarious, came from a purported cocaine and fentanyl dealer whom Constable Senior had known for 2 months. That's Henry. So, yeah. This is kind of a, you're trusting this drug dealer that he's not going to do it violently? Maybe he will, right? There's, yeah. And, maybe you shouldn't trust him that he just wants to rip off a locker. Maybe he actually wants to, to kill somebody. Wouldn't you hate to have run a license plate for somebody who then later ends up dead in, a gang hit? Constable Senior was not using his noodle at this particular moment. The defense submitted that the evidence of mens rea for this offense was entirely circumstantial, and that the Crown had failed to prove beyond reasonable doubt that the only reasonable inference was that Constable Senior knew that he was wrong with respect to his use of the computer service for this purpose. So in the previous video, we went over details about circumstantial cases. I'm not going to go over that here, but it's worth remembering in terms of the only reasonable inference. It is the view of this court that there is only one conclusion as to Constable Senior's knowledge and intention. Constable Senior knew that in doing this, he was putting his neck on the line, to use his own words. Ouch. It's always bad when your own words are being used in a court decision. Constable Senior's knowledge is further demonstrated by his comments that he would have to get this done off radar and get someone to backdoor channel it. A reasonable person in Constable Senior's circumstance would conclude this use of the computer database was dishonest. Constable Senior himself knew this and said as much. Constable Senior intended to commit the prohibited act with knowledge that he was wrong with respect to his use of the computer service. Constable Senior is, therefore, guilty of unauthorized use of a computer as it relates to Henry. So, he's convicted with respect to that in terms of misusing the computer. But there's a second charge there in terms of the breach of the public trust. So as for the breach of trust, Constable Senior was certainly an official acting in connection with the duties of his office. He was a police officer interacting with a person he believed to be his confidential human source, and a real bad guy, a drug trafficker and worse. So it is true that by the time of this request, Henry had built a rapport with Constable Senior. A relationship of trust had developed. Constable Senior may well have believed that the future of their working relationship would be affected if this information was not provided. So, Constable Senior is getting really valuable information, he thinks, that's leading to big-time seizures of drugs, weapons, money. And he thinks he can trust this guy, and that if he doesn't do this thing, he's not going to continue to get this information. Well, yeah, that's a problem. And ultimately, he was supposed to have been meeting Henry and communicating with Henry with somebody else watching him, to somebody else who can say, hey, this is not a good idea. But they specifically engineered a set of circumstances where Constable Senior would be meeting with him on his own, because his partner basically would mysteriously flake out every time this was necessary. So, however, this court does not accept that Constable Senior believed that a quid pro quo for confidential human source information was lawful in the course of his duties. My understanding is that Constable Senior didn't testify, so it's going to be hard for him to establish his belief based on that. Constable Senior clearly knew it was wrong to provide this information to Henry. He tried many times to get Henry to consider other means of obtaining this information. Constable Senior told Henry that it would get him in trouble, and that by doing it, he had put his neck on the line. Constable Senior may well have believed that getting this information for Henry would further his relationship with Henry and further his career in law enforcement. However, he also knew that it was wrong. As a public official, a police officer, Constable Senior was not at liberty to use any means necessary to further his work with a confidential source and to further his career, including breaking the law, and he knew that. If he was obtaining this information to further his career in law enforcement, as the defense suggested he may have been his purpose, this is not helpful to him. The defense also submitted that Constable Senior knew that this license plate belonged to a purported high-level drug trafficker, and it was not an unreasonable inference from the evidence that Constable Senior believed that fulfilling this request was part of a lawful investigation, that this was information Henry needed in order to be able to provide information to the police in future. So basically, the theory that the defense was arguing here is that they give this information to Henry. Henry does some further investigation, and then Henry says, hey, here's where you guys need to go. This is your next steps. Go raid this place. And if that was what the evidence supported, that might be a lawful excuse. So Henry's reason for wanting this information was plainly put to Constable Senior on several occasions. It is the view of this court that this is not a reasonable inference on the evidence. Henry's reason for wanting this evidence or information was plainly put to Constable Senior on several occasions. It was clear that this was not going to be a locker for the police to raid. This was different. Henry was going to rip the locker and take back things that he said were rightfully his. His purpose was absolutely clear. So this disclosure of confidential information for the purposes of assisting the commission of a criminal offense, because Henry robbing somebody would be a criminal offense, was done for a purpose far removed from the public good. At least in part, there was a corrupt purpose that furthered criminal activity, including organized crime. Whoops. The conduct of Constable Senior represented a serious and marked departure from the standards expected of an individual in his position of public trust, given that he knew it was wrong, knew he was putting his neck on the line, and knew that Henry, a mid-level organized crime figure, would use this information to follow another individual around and eventually rip drugs from them. Constable Senior is guilty of breach of trust as it relates to disclosing this information to Henry. All right, so let's cut it off here. This is at a little bit more than an hour. There's a lot going on here. So they got him on some uses of the database, and it's kind of interesting to note that where they do and don't get him here, because sometimes when it's related to this Henry figure, sometimes that's fatal to them, because Henry is, because of Henry's involvement and sort of mistakes made, I guess, in the way they set this up. Because when they're having Henry sort of specifically reject this money, that ultimately did not, that didn't help them get convictions. However, when they have Henry going at, when he's saying, hey, I need this in order to further criminal goals, that was very much helpful to them. So this is all a sort of complicated scenario there. And yeah. Now, the next video is going to get into the much more sort of chaotic part of possessing a firearm obtained by crime, possession of weapons for purposes dangerous to the public peace, attempted robbery, and trafficking in cocaine. So these are much more serious charges. We'll deal with that next time, so I hope you'll stick around and watch that one. I want to get through this one. I know it's been a lengthy video because trying to dig into 188 pages of decision, but ultimately this is going to be a really interesting case in terms of the entrapment. And so when that decision comes out, which is in the future at some point, hopefully I'll be able to sort of explain that and people will be following what's going on here. Anyway, thank you for watching. Please like this video. Please share it with your friends. Please subscribe to see more content. I know these long sort of deep dives are not necessarily for everyone, but I try to provide a mix of content here. So let me know if you want me to do more short cases, more of the long cases. I suppose if you've watched this far, you're probably okay with the long cases. So maybe a bias survey. Forget that. All right. I also want to thank my Patreon supporters. There's a link to my Patreon in the description below. Those are at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Demo, Canada's National Farms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, BCAMF.org, Andrew Schaefer, and the Canadian Shooting Sports Association. I also want to thank the $30 supporters, Sights and Arms Limited and Marc-Olivier Damour, and at $20, Andrew Elsich and Adam Meester, as well as Cameron Johnson, Dale Nesbitt, Mark Whittington, and Matt Ward. I also want to thank my $10 supporters who will be in the crawl immediately following. Thank you once again for watching. I hope this has armed you with knowledge, and see you next time. I've also got some big things coming, but I don't want to spoil them, so... Anyway, yeah, I'm excited for things I can't share with you yet. That's always a tough spot. Anyway, see you next time.